Good. Well, good morning to our attendees and good morning, Moys. This is the latest chapter in the Radcliffe Talks Real Estate series of webinars that take the form of a fireside chat. And today, I'm delighted to welcome Moys Gamble from IREDD, Intelligent Real Estate Due Diligence, to help unpack practical tips for dealing with risk in real estate transactions, unlocking and maximising gross development value. Now, as we all know, developing land is a complicated and difficult business. Hence, 20% G.D.V is market norm for developers, maybe a bit less, 15%, 6% on affordable housing. And land is a finite resource, and there may be competing interests, statutory, common law, equitable. And all that is in play, or often in play, in development scenarios. So the aim of our fireside chat today is going to be to help explain legal indemnity insurance, what it is, what it can do, how you go about getting it, and we will have practical tips in part two after we've done part one, the overview, and then part three will be an application, an opportunity to apply what we've learned to that. We will look to do Q&As at the end if we have time. If people have a burning question, they can put it up in the Q&A and we'll attempt to answer it as we go. Only the hosts, us, and can see the questions. If people want a bit of privacy, questions that we don't get a chance to deal with in the Q&A, we're happy to take by email after the event. Everyone will get the slide pack at the end, and we'll try and offer our three takeaways. So that's the format of the webinar. And we will get underway. So, Moys, please, an overview. What is legal indemnity insurance?
I think I should preface my remarks by saying it is going to be a very high-level overview because we could spend the next week sitting here talking about legal indemnities.
Of course.
But fundamentally, it's insurance which is aimed at protecting the legal right to use and own property. Mm-hmm. So if anybody comes from the outside world and claims they have a better right to use your real estate than you do, or that you don't own part of it, then the insurance is designed to protect against that. And the overall aim of the insurance is to ensure that the title to the property that you own always is good and marketable.
Excellent. Thank you very much for that. It's not a handbook, as you say, what we're going to present. No doubt there could be textbooks written on the subject, but we're doing a high-level overview. And I should just say that we've got a range of attendees, I think it's 120, something of that order, from trainees, people who are at the early stages of their legal career, to partners who are experienced, very experienced. So we'll try and hope that there's something for everyone. So how does it work? Moys, please help us with that.
So unlike other insurance, there's only one premium payable. It's not renewable.
Okay.
And a traditional legal indemnity policy, which is against a known risk like an easement or a covenant.
Yes.
Which I think most of the audience will be familiar with.
Yes.
It's a policy which says from this day forth, if somebody asserts that they have the benefit of that easement or covenant against you, then this policy will respond.
So,
and it's generally A-rated cover, because it has to be relied on by investors and lenders.
Yes.
And it's a snapshot at the time that the policy is incepted. So it doesn't cover you if a future easement or covenant is created. But traditionally it was created, this class of insurance was created to protect against known risks from a date in time.
And that date in time is usually presumably the inception of cover, because as we know, with gathering passage of time, rights can crystallise and change. So I think there's a rule of thumb when it's reviewed, Is there a period of time that's often?
So although they're expressed to be in perpetuity,
Yes.
if you have a title policy which includes unknown risks
Yes, unknowns.
and is wider than just unknown covenant or easement,
Yes.
then there's an argument to say that after about 7 years, it's going to go out of date because it's a snapshot at the time. It's much like a certificate on title.
Yes.
In insurance form.
Excellent, thank you.
And the other thing that distinguishes it from insurance generally
Yes.
is that the limits of indemnity are very big.
That sounds reassuring.
Well, it is if you're dealing in it, because because the limits tend to be calculated with reference to the actual value of the property or the actual amount that the lender is loaning on the property.
Yes, so either G.D.V or the lender's investment.
Correct.
Yes, and I suppose just to make the point while it's fresh in our mind, lawyers tend to be risk averse, understandably, and insurers, you're in the business of assessing risk and mitigating risk.
I tend to say that lawyers investigate and identify risk, but then don't like the fact that they've done that because they think their PI is at risk.
Yes.
Whereas some insurers wake up and say, oh, there's a risk there. Insurers love risk because they can charge a premium for it.
Absolutely. Good. Okay. So how does it work?
Like all insurance, it just provides financial compensation.
Yes.
So there's a whole conversation we can have about whether damages are an adequate remedy, but all an insurer can really provide you is a financial remedy.
Understood.
And so, and you can see from that definition, it's financial compensation for actual loss arising from an insured risk. So obviously, when you're putting these things together, you need to be a bit careful about your definition of insured risk.
Absolutely. I mean, in old language, one would speak of an insured peril. Maybe that language is no longer, but that's the basic concept.
In part 2 practical tips, we'll discuss that.
Fine. I'll move us forward. We covered insured risk, use and ownership. I think we have. So how does it work in terms of loss remedies and costs?
So I can't count the number of times that somebody's come to me and said, I'd like a title policy, I want you to wrap this development. But if I don't get planning and it doesn't go ahead, then the G.D.V, the projected G.D.V is X million. So if you could just pay me that'd be fine. I say, no, it's not profit or hope value, it's actual loss.
Of course.
And when you look at the heads of loss in a legal indemnity policy, they're very broad because the limits are very high and it extends to the whole value of the loan. It extends to the cost of altering and demolishing the property if you have to comply with the court order.
Yes.
That doesn't go your way. It extends to legal costs, it extends to abortive planning costs. And so there's a tendency for an insurer to think, wow, if this happens, I get all my money back. But as we'll see in part 2, that's not how it works.
And just on that point, there have obviously been injunctions where developers have high-profile cases. There was a Supreme Court case not so long ago on the restrictive covenant where the developer took a rather bold line and just went ahead despite protests, and the order was knock it down. And there have been rights of right cases, well-known cases where there's been infringing, actionable infringements which have caused physical fabric to be required to be taken down, although I think deals were done to keep it in place, but also confidential as to how much ended up had to change hands to allow that.
I'm familiar with the cases you're talking about, Clive, but
I thought you might be.
but nobody knows what happened.
Remedies, just on mitigation. That lawyers are very familiar with.
So related to so you have a very big limit, you have very broad coverage.
Yes.
And that can get insurers overly excited.
Yes.
But the insurer, as we'll see in part 2, will always say, I'm looking for the remedy that costs me the least amount of money, not the remedy that gives you the most amount of money. So we'll put our first question.
Yes, sorry, I think
it's more of a comment than a question.
I thought the session was practical tips for dealing with risk in real estate transaction, unlocking and maximising DVD. But I think the answer to that is it is, and we're getting there, so to speak. We're just giving first of all the overview, the part one. I don't know at what point this the questionnaire arrived. We're just explaining what the policy is and does before we get to the practical application. So just in terms of expense, Moys, can you say something on that?
So the expense varies, the cost varies widely in terms of the underwriter's perception of the risk.
Yes.
But overall, if you're wondering how much it's going to cost to apply this sort of insurance, it's going to be something like £1,000 per million of cover.
Right.
So for 20 million of cover, it's £20,000.
That sounds pretty reasonable to me.
It's generally about a third of what it would cost to do legal research to perform a good and marketable.
Interesting. And that cost will go into the developer's line of expense incurred in building out the development.
It will, yeah.
If there's any issue about viability or reducing it, for example, affordable housing requirement. Okay. So just a word about IREDD before we get on to part two and the practical issues. Just talk us through how this concept has arisen from your perspective of so avoiding too much duplication, I think would be one way of putting it.
In about 2010, with my partner, Rob McMahon, we started IREDD, and we started in response to a phenomenon we'd observed, which is a vendor prepares a setup or compiles a data room. And that's usually quite high quality information. The buyer comes along and looks at the data room and says, that looks very interesting to me. The buyer's lawyers come along and say, well, all of that was prepared for the vendor in preparing it for sale. But I now need to do that work for you because I'm acting for you.
Yes.
And the buyer says, great, now I need a funder. And the funder comes along and says, well, I can see all this due diligence, it's all terrific, but that bit was prepared for your benefit, that bit was prepared for your benefit. I need somebody to do it for me. And that's generally when we put our hand in and say, now would be a good time for an insurer to look at this due diligence, which is available.
Yes.
Assess whether it is high quality and well compiled. And if it's good quality, then we can put a good marketable title around it. And what that means in practical terms is that you can reduce your financing period from months to weeks.
That sounds good. Speed is often the essence. And in our practical example, we've got quite a tight timetable to achieve a sale.
So I'm reminded of a commercial loan entity that said, but notes, we get our loans out the door in 56 days. That's 56 days after they've made the credit decision, after the loan's been taken, after they've spent months assessing the viability of the borrower and the project and the quality of the real estate asset. That's a further 56 days before money leaves the bank.
Time can be of the essence.
Yeah.
Okay, so just a word on some of the common risks that we're going to be looking at. You've touched on easements. Typically rights of way, typically ransom strips, I think certainly there are issues that cross my desk quite regularly, as do restrictive covenants. What other risks do you typically see that require insurance?
So the reference to the marketable title risk will come on to, but that's the concept of taking due diligence and ensuring any risks that you can see which are known in there, which can be covenants, easements, ransom strips, and so on.
Yes.
And also ensuring any unknown risks. And the way that works is the underwriter makes a risk assessment and says, well, if the risks haven't come to light so far, this property has been traded several times in the last 10 years. It's been refinanced twice.
Yes.
And I'm prepared to bet that even if there are risks that we don't know about, nobody's going to enforce their rights. Just a quick word on no search covers, because I'm often asked for no search covers by somebody who's running short of time or their searches have expired. And so we should distinguish between no search covers and good marketable title covers.
Yes, no, please do clarify that.
I'll find it as quickly as I can.
Thank you.
If you take a no search policy, you're protected against something which would have appeared in a search had you performed a search. If it doesn't appear in the search, then you're not protected. But that leads to a lot of confusion for insurers who say, well, I took this no search policy and it turns out there is a breach of building regulations. which is covered by the policy. And say, well, it's not, it's only covered by the policy if it would appear in the search. But if it's not in the search, you're not covered, and you're not covered.
I can see why there's some confusion about that, because you might take the view, well,
So,
why not do a search? But
that's why no search policies are very cheap.
okay, planning and section 106 obligations, is that something you frequently see? We'll be touching upon that
So
in some
we
detail.
quite frequently see undischarged section 106 obligations, either because the scheme has changed or they're historic. But as you know, they have the force of a restricted covenant.
Absolutely.
So they can be pretty serious. And rights to life, I think, is a very well-known class that be covered.
Yes, and is it your perception that the market's hardening for getting insurance in that space? Commentators say that
has become a victim of its own success because it's a relatively new class of insurance and it's been written a lot in the last 10, 15 years. And now most people assume there's rights to life behind a development. Yes. And they proceed accordingly. And just
to agreed conduct a little later, but yeah.
So just very quickly, it's a vast area. There's judicial review, there's mines and minerals, there's unexpected archaeological discovery, there's unexpected ordnance discovery. Yes. There are more risks than like in that.
Yes, no, again, very recently I've been dealing with Museum of London Archaeological survey. They need to be on site at certain groundwork stage, which then can interfere with can you commence development. And we'll move on. So that's a very helpful overview. So a summary of risk-based assessment, then, Moys, please.
So we're not talking about replacing lawyers. We're talking about using
not replacing lawyers. Good. The audience will be very pleased to hear that.
Because and lawyers are 99% of our clients because they're people who get presented with the issues that we can deal in.
Yes.
But we are talking about using a risk assessment to transfer institutional risk to make it institutionally acceptable to a lender.
Yes.
So you need an IREDD covenant to do that.
Yes.
And you need the lender to be happy. And if a lender can get risk transfer, it also transfers away from the lawyer's regulatory liabilities.
And as we said before, you need planning permission to unlock development. But even more importantly, perhaps, or this planning permission is a necessary but not a sufficient condition because most developers are going to need funding, and the funder will not lend unless they're comfortable. And if there are issues, then they will require comfort from an insurer.
Absolutely.
And that's the unlocking of possibility of development value.
And broadly, the insurance approach, unlike the legal approach, is let's leave this risk alone and not excavate it. We know it's there. Yeah. But we'll take a view on the magnitude of it, the probability of it actually happening, and what we can do to solve it. Excellent.
Thank you. So just that perhaps you could just speak to a few examples of risk-based approach.
So I'll try and do this as quickly as I can.
Of course.
But an example was a rebalancing of a pension fund, and the trustees on one of the receiving funds said, "Hang on, you've had hundreds of millions of pounds of real estate into our fund. We don't have any side real estate due diligence." And the advisors all scratched their heads and said, "Oh, so we've only got about 2 weeks. What are we going to do?" And because it was institutional quality investment and due diligence, and because there was nothing happening under the surface, because the real estate was staying in the same entity from the land registry point of view, we were able to convince the underwriter that a £300 million wrapper could be put around it. And another example, there are a few there, but I'll just pick this one up, is a household retailer that we acted for. It was selling a chain of stores, its whole UK chain. And they said, well, we've got 4 weeks to do this.
4 weeks?
So it's going to be quick. And they said, we don't want to be subject to due diligence bids because we're putting a good amount of title policy in the data room for bidders to look at. And if you can satisfy yourself that that policy does what you need, then you just make a bid on that basis and you take it as is.
Okay.
That's quite a radical approach. But
it sounds interesting.
Transaction with only 2 lawyers.
Wow. That's impressive. Excellent. So, application of legal indemnity in terms of benefits, how do you see them?
I think the biggest benefit is point 2 on that slide.
Mm-hmm.
Because if you go to an insurer and the insurer says, that looks a bit risky for me, I don't want to do it.
I won't touch it with a barge pole.
Yeah, that's a really good indication that somebody with a checkbook, whose business it is to take risk,
Yeah,
thinks this is too risky.
Yeah.
And if they think it's too risky, maybe you should reconsider.
that is a serious red flag.
Yeah.
And that's a cheaper and faster way of getting to that point than
Absolutely.
full legal due diligence.
Absolutely.
Yeah, and speed, I think you've talked about unlocking the funding.
Because this is risk assessment, it's typically in a transaction, you have a set of known risks and they're insured. And they are already insured, in which case you take it as a successor in title.
Yes.
It all passes down to you. Or you name them in the policy, and you add on unknown risks, and then you present it to a funder.
Okay,
And funding can occur very quickly then.
excellent. Now, okay, so that's very helpful. Moys, you've explained to us the essence of legal indemnity insurance and how it works. So if we move on to part 2, which is practical tips, the first thing is terminology. Who's who in the insurance market? Can you help clarify? I think there is uncertainty in the world of insurance, or from the outside anyway.
So in my view, the insurance market is quite opaque. And in legal indemnities, it's particularly opaque. So people often approach us and say, well, I went to talk to this underwriter and this underwriter. Now I talk to Aon and Willis. I talk to these people. And none of them came back with anything, so I thought I'd give you a try. I tend to say, well, you've approached 2 brokers. We're a broker, and they're going to approach the rest of the market. You've also approached half the market who are insurers. And the distinction between brokers and insurers is very important. And because if you are an insured and you're approaching the insurance markets, I'd recommend you do it through a broker. Because the broker is the only person in the insurance market who has a positive duty of care towards the insured. Insurers have a duty of care to the shareholders in the insurer. And the distinction between a broker and an insurer is apparently not very clear. Absent the big 3 brokers. So I'm just stressing that if you don't know who you're dealing with, it's worth checking.
Absolutely. Okay, that's a helpful. And did you just want to say something about the Insurance Act 2015? And I think you say it codifies the Aberium Fideis utmost good faith duty that exists in insurance.
Yeah, so
contracts.
So this goes to conduct generally and how to stay on the right side of your insurance.
Yes.
And insurance contracts are insurance of utmost good faith, Aberium Fideis. And these duties are now being codified to a greater or lesser extent in the Insurance Act 2015. And by way of example, somebody came to me the other day and we insured a restricted covenant. It was a very simple case. It was a covenant against using the property for this use. They were converting it to that use and the covenant was on, so we did it. And then there was a claim and the insurer said, I'm not paying that claim. And we said, why not? And the insurer said, because it turns out that the owner before this owner had already contacted the beneficiary and told them that if the development occurred, it would all be good. But our insurer didn't know that. And so the insurer said, well, I'm not sure your insurer didn't know that. But the insurer took the view that it was an innocent misrepresentation by our insurer. So what that meant was there were no penalties, fines, or other action. But what it meant was the refund got refunded to our insurer.
I was just going to say premium back, but no cover.
And the contract was void ab initio.
Yes.
So there was no cover, and that's because the insured might have tried a bit harder to find out what the situation was before they went for policy.
Interesting. We'll come on to that in the sense of disclosure, but not infrequently. I had a developer client the other day who've been ongoing matter, and his concern is if he speaks to the people that have already asserted they've got the benefit of the covenant, then when he goes to the insurance market, that's going to be a problem for getting cover. But I pointed out, well, there's a letter you've received. Okay, the information went to your planning agent, but you're fixed with that knowledge. But anyway, we'll move on.
There's a solution to that, Clive, which we're coming to.
Yeah. So who is the insured? Lender versus owner cover, because we touched on at the start the fact that the owner is looking for its gross development value, but to achieve that, it needs funding, and the funder wants to have its funding protected, not necessarily the higher G.D.V protected. So can you just talk us through that, please?
So in general, you can either insure the lender or the owner, or you might insure both.
Mm-hmm.
If you insure the owner, then you automatically insure the lender, their tenants, their successors in title, and all those people. If you insure the lender, then you're insuring the lender and any successors entitled to the lender. Mm-hmm. So if the lender sells its loan book, then the subsequent lender is covered. But lender cover is a lot cheaper and easier to obtain because the difference between the market value of the land and the amount of the loan constitutes the virtual excellence of the insured. And our experience is that owner developers, borrowers, are much more optimistic about the prospects of success than the lender is.
Yes.
So you can save some money and time by just insuring the lender. Because if you're the owner, all you really want is to unlock the funding.
Absolutely.
You're not particularly concerned about your exposure to the risk because you're already quite exposed.
That's interesting. Thank you. Do you want to just say something about joint insurance?
I do. So the big issue to watch here, if you're picking who you're insuring, is to make sure that you have non-vitiation wording which works in the policy. Mm-hmm. So an example is, I was asked to review a policy over there where the lender had said, I want to be the named insured because that's the practice in many insurance contracts, but it's not in legal indemnities. And the insurer said, that's fine. So they issued an endorsement which named the lender. So then you had the insured was the borrower and the lender. Mm-hmm. But what nobody had realised was there was no non-vitiation wording in the policy. So anything the borrower did was also cover. But the solution to that is to insert wording in which says the act of any insured will not affect the entitlement of another insured. And that way you create a composite arrangement where you have two insureds who are independent under the same contract.
So perhaps the key message is think carefully and then look and study the wording in the endorsements on the policy.
Yeah.
Thank you, Moys. Now, moving on, in terms of limits, we've sort of touched upon this, indemnity excess premium, G.D.V. I think the example we're going to come on to, I think development value 25 million gross G.D.V or something of that order, but the loan maybe 20 million, let's say. You've talked about that already a little bit, but just want to say a little bit more about that.
Yeah, so in general, our business is making real estate institutionally acceptable, which is my way of saying fundable.
Yes.
So, and you say generally insure the loan out with the G.D.V, but there are some situations where that would be foolish. Mm-hmm. And one was a rights to light I had recently, where the rights to light compensation budget was £10,000.
Okay, fairly modest.
The loan amount was about 200 billion.
Goodness me.
So the lender said, well, I'd like to see my loan amount on the front of the policy. And I said, if I do that, it'll just make it look like I don't know. So after some doing we managed to agree more sensible than that.
Good. And sorry, you go.
So you just mention a couple of those things.
Yes.
So the excess point, insurers very often say, well, I'm not sure about that risk, so I'll just put an excess in.
And the more concerned they are, the bigger the excess, presumably.
Yeah. Well, they might be trying to do the insured a favour by bringing the premium down by increasing the excess.
Right.
Yeah. But my experience is that the combination of premium and excess is normally greater than the combination of a premium that would be a bit higher but carry no excess. And as a developer, you'll find that your development appraisal has in it a line which is the sum of the excess and the premium. despite the fact that the excess is not necessarily payable, tends to be included in a lender's appraisal. So accessing isn't a way to make it go away.
No, I think, well, developers typically will put everything in to the cost column because that reduces the potential for obligations from the local planning authority, and gives them more wriggle room on viability. So it's beneficial, I think, from their point of view to do it that way.
Yeah.
So
there was another point I wanted to ask.
Yes, please do.
Because as well as making things institutionally acceptable, we're also about making it affordable.
Yes.
And so one of the key considerations when you're doing that is to ensure that the premium follows the path of the development as much as possible.
Yes.
Because you might have a very big development which is going to take 7-10 years to build.
Of course.
So you're going to pay an enormous premium at the start. So in this situation, we've put together staged covers.
Mm.
And traditionally that's on acquisition of the site. You pay a premium which covers you for the site value.
Mm-hmm.
And then on planning,
mm-hmm.
once it's issued, you then get a premium which reflects the G.D.V. But in our experience, there are better ways to do it, because that trigger for the second stage premium might not follow your funding. So we tend to tie things like the creation of the leasehold interest in a sale and lease back. Or we tie it to the occurrence of a funding event. And one thing I'd like to ask you, Clive, is whether it's possible to get a certain definition of a material start implementation of a planning permission.
Certainly. Well, the first point to note is you correctly identified the fact that the grant of planning permission is not the resolution to grant, which will always be subject to the Section 106 agreement. So the timing sequentially is resolution to grant from the committee, although let's talk about change to give more powers to officers, but that will be the small stuff, not the big stuff. Resolution to grant subject to a Section 106 agreement. So to the extent to which the heads of terms have been thrashed out in the run up to the application going before the committee, that process could be quicker, but often it is quite a long process. And the planning permission decision notice, which constitutes the grant of the permission, will not emerge until the Section 106 agreement has been signed, sealed and delivered. And local planning authorities are very concerned about any goodies, planning obligations falling down between the cracks in the floorboards. So they tend to make sure that everybody potentially is on the hook under the Section 106. So in terms of implementing the permission, what you have to look at are the pre-commencement conditions, because there is a tendency to ever increasing conditions imposed upon a grant of planning permission. They're discussed and negotiated, hopefully, well in advance between the developer, the local planning authority, input from interested parties, etc. But the definition of commencement or implementation of a planning permission, it's very low threshold. All you've got to do is start a bit of demolition of fabric or digging a bit of a trench to put services in, that sort of thing. It's defined in, I think, Section 56 of the Town and County Planning Act 1990 as amended. But it's a pretty low bar to start development. So I'm not sure if I've actually answered your question, but you could tie it into the statutory language of.
That's my question, because if you get it wrong and your stage 2 trigger isn't independently verifiable, then if you get a claim, the insurer will say, well, you haven't paid your stage 2 premium, and you'll say, but it's not due yet. They'll say, well, in our opinion, that event has already occurred. And if you don't pay your stage 2 premium under most stage policies, it's not just stage 2 you don't get. They also say that stage 1 doesn't exist.
Oh, right. Yeah.
So it can be pretty
quite critical.
And if it's a big claim, the insurer is very motivated to
Sure.
Find a reason that it can avoid or minimise its liability.
Yes, understood.
But stage cover is terrific because it gets the insurer involved, so anything that happens in an insured environment from now on.
Yes.
Because if you wait until something has happened, then the insurer is going to turn around and say, well, I can't insure that because it's on fire. Because the claim's already happening.
Understood. Yeah. So I think that it could be tied to commencement or implementation. Unfortunately, the language is to implement a planning permission means to start to use the right to develop land, which that constitutes the permission, the operational wording of that permission, but it's subject to the conditionality. And you do get issues, and this is going to be one of my takeaway points, in fact, where there is uncertainty over whether there was implementation, either because of the time limit that's imposed on the permission, typically 3 years from the date of the grant to commence development, because of the clearance of pre-commencement conditions. And I have had a case where happily the council has now granted a lawful development certificate to confirm that we did actually commence development. Before they were arguing that we hadn't, but happily that's wrong. But the point is, you can apply for a lawful development certificate, which is purely fact and law. Did you commence development within the time or not? Yes or no? It's nothing to do with the planning merits. So there is a route to getting certainty, which you've already indicated as lawyers we all love, and clients like certainty.
But what I try and tie at this stage to is the position where you've got your funding flying.
Of course.
Because it's much better to do it with the funders.
Absolutely. Yes. So disclosure, Moys, your rule of thumb on this, your tip on this.
So the fairly general point here is over disclose to the insurer at all times, but don't tell anybody else anything about it.
Right. And share everything with the insurer.
And frequently an insurer will say to you, well, that's fine. I see what's happening. So just go ahead, keep talking to that person if it's an agreed conduct extension.
Mm-hmm.
And just tell me when you think the excess is liable to be in danger of running out, and then I'll treat it as a claim. But if you go to the claims person, you say, well, and they say, what happened? You say, well, this happened. And they say, well, did you tell us? And you say, no. Then you might find the claims person doesn't share the underwriter's optimistic assessment of the situation, and might take the opportunity to say, well, if you told us that, we would have treated it differently. So my practical tip here is tell the insurer everything.
Yes.
Until you get an email from the underwriter which says, stop sending me all this stuff. Just go and do it.
Right.
But you need a really clear indication that you're allowed to do it.
Okay, that's very helpful. Thank you. Strategy. You touched upon good and marketable titles, site assembly. What would you like to say on that?
The point I'd like to make on this is you can apply these insurances in all different ways and in all different times.
Yes.
So the example I'm thinking of is a site acquisition.
Yes.
Which was about 15 titles, which were meshed together, but they had unregistered bits and they had rights of way over each other. It was all a mess. But the client just needed to fund the acquisition of the site before going for development funding.
Yeah.
So I went to a land registry service and I downloaded the titles, sorted the easements into date order, showed the insurer and said, well, on a continued use basis, not anticipating development, but we just need to get this done now. Can you provide us a good amount of flood policy? And they came back 2 days later and said, yeah, for 20 million cover, we'll charge you £12,000.
That sounds like a good deal.
I thought it was a good deal, but the lender in that case said it was too quick and too cheap, and I don't trust it.
Oh, right.
So we had to slow down a bit, but it was about that price when we put it in place.
Sounds like good value to me.
Yeah, I thought it was. And the other points on the slide, which is another practical tip, which is about restraining trade.
Yes. How do you see restraint of trade in this context?
So there's an argument that a restrictive covenant can be a restraint of trade.
Interesting.
And this was a case where there was an office block in an estate. And around the office block, there was a hotel, a gym, a daycare centre, a car dealership. And all of these uses had corresponding entries on our title.
Yes.
Which said you can't use this as a gym or a daycare centre or a hotel or a supermarket. And it started with the supermarket covenant because the underwriter said, well, I think there's the groceries regulations. And they make these supermarket covenants very hard to enforce because they're competitive.
Yes.
So we took that and ran with it, and we got most of those uses reinstated for the block.
Interesting.
And so the client was able to sell the land with a massively expanded use class,
which obviously means increased GDV.
It tripled the value.
Tripled. Wow.
Yeah.
Interesting.
So just bear in mind other reasons a restricted covenant might not be enforceable.
Thank you, Moys, for that. Rights of light cutbacks, and we're going to talk about appropriation briefly, or perhaps you could just address that.
So
very common obviously in crowded London and other big major cities.
Yeah, I'm going to assume that everybody knows what a right to light. What a right to light is. It's the infringement of easement for light.
Absolutely, and it's
prescription considerations.
Yes.
And loss of grant and all that sort of stuff.
Yes.
But the point is, if you have an infringement which is actionable,
yes,
all infringements are actionable. But if you have an infringement which is so actionable, you think there really is likelihood of injunction, then you don't assess damages by reference to how much light is being lost and the value of that light on the affected property. You assess it by how much profit the developer is making out that infringes. And that's called the developer's profit assessment. And that is traditionally much higher than the book value assessment. And so an insurer will generally say, I'd like to see a cutback. That means cut back. So for your developer to not infringe anything, how far would you have to cut it back?
Yes.
And if that cutback is performed in respect of all the properties that are affected, then you're left with a little sliver of your development and a massive bill.
Yeah.
And your profit is going to be extremely high, and the insurer will get a very big number on their desk, and they'll say, well, that's millions. So the premium has just gone up about 20-fold.
Yeah.
So with the insurer's agreement, what we tend to do is say, let's just cut back the ones we're worried about.
Yeah.
Is there a building here that is so badly affected that we think that damages in lieu of injunction will be the measure?
Yeah.
And if it is, let's cut back that one.
Yeah.
But let's leave all the others there because they're insured.
Interesting.
And that
good strategy.
In that way, you get the developer's profit calculation to be more in line with book value. So the premium doesn't suddenly shoot off the
scale.
Yeah.
Interesting. And as a I think you wanted to ask about appropriation for land for planning purposes, I think.
I did because the reality of appropriation is it's much messier than people think.
Yes.
And there are resolutions to grant, and there's unclear documentation, and you can't quite tell where to go.
Well, the thing to say about that is it's slightly odd language in section 203 to 205 of the Housing and Planning Act, which 2016, which doesn't take quite the wording that was in section, I think it's 237 of the Town and Country Planning Act 1990. But the basic point is it allows a local authority to cleanse the title of land. And by cleansing the title, what I mean is it converts the right that's being infringed, which might be a restrictive covenant or it might be an interference with light, into compensatory damages only, as opposed to the prospect of a very worrying injunction, which brings things to, or can bring things to, a shuddering halt, interim or final. So it's quite common for local authorities where they own land themselves. They're the landowner. They can be the developer, or they can do it on behalf of the developer, and they're the local planning authority. So they appropriate land for planning purposes And that appropriation event itself has the effect in law of, which I've just described, of converting any rights that have been overridden into a right to compensation. So you remove the risk of an injunction, in essence. And sometimes local authorities in London, the ones that are very used to this sort of thing, I'm talking of Westminster, City of London, Southwark, Tower Hamlets, etc., they will deploy these powers on behalf of a developer, and there are various sale and leaseback mechanisms and various ways in which this can be done, but it's done to achieve the same end, the cleansing of the title. Development can go ahead knowing that it's going to only be damages, it's not going to be an injunction if there is a infringement of that right, whether it's under a covenant or light.
Always a bit of a red flag for us if somebody says, if it goes wrong, I'll just get the council to agree it.
Yes, I think things are a bit more complicated than that. It's a bit like developers say, have you got planning yet? Well, hang on a minute, what do you actually mean? There's a resolution to grant, there's a decision notice, there's the section 106 before that we've already spoken about, there's clearing the pre-commencement conditions. But we need to move on. Did you just want to touch upon unexpected benefits and agreed conduct before we get to our example?
Yeah, so very quickly, unexpected benefits. I was presented with a bright light the other day.
Yes.
The budget was between £5,000 and £10,000.
Yes.
Cost of insurance was going to be at least £30,000.
Mm-hmm.
So the insurance owner said, well, that's crazy. Why would I spend that much? And I thought that's right. And then I looked in the press, and it was a £100 million development. It had been all over the papers. And it was very high profile, and I had no idea. So I ran them back and said, chaps, it's much more like you're going on a plane. It's going to be £10,000 you have to pay then.
Yeah.
But it's going to cost you a lot in surveyors and lawyers to get there.
Yeah.
And it strikes me you don't know much about this subject area. And so your relaxed attitude is not a reflection of the size of the risk. It's a reflection of the fact you're not aware of the consequences.
Yeah.
So
you put that very diplomatically, I'm sure, Moys, as you always would.
Yeah. So not diplomatically enough. But so the benefit of getting access to surveyors and people who know how to do claims,
yes,
via the insurer, can't be underestimated.
No.
And agreed conduct, I think we've touched on this all through,
yes,
and we should have really done it at the start. But traditionally, you have an insurance policy, you put it in a drawer, and you never say anything about it.
Wait and see.
Yeah, but insurers have decided that it's much better if you can go and try and deal with the situation.
Yeah,
it stops you getting an injunction.
Yeah,
because you haven't contacted somebody.
Yeah.
It chimes very well with the developer's duty to be a good neighbour.
Yeah.
And we've put together some amazing agreed conduct policies in the past.
And that's predominantly in the rights to light space with the RICS.
Yeah.
Recently.
It is, but let me just squeeze this one in, if I can.
Please.
A covenant in a transfer to only develop office. And this chap came to me and said, look, I've got a covenant in my transfer, which prevents me developing resi.
Yes.
I want to develop resi. I said, well, you're the person who agreed that 3 years ago in this transfer.
Yes.
And he said, I am. And I said, well, how do you think we're going to insure you against that? And we insured him by using the rights of light developer's profit analysis.
Okay.
And saying, if we put an excess here, which is about a third of your profit, we can insure the rest. We did that. That was amazing. So he
great creative thinking.
You go and negotiate. Yeah.
Okay. Loss and mitigation. Do you just want to say a quick word about this before we get on to our scenario?
Yeah, I'm conscious of time.
Yeah.
But
take it at pace.
So at the start, we talked about this.
Yeah.
If it's judicial review, the policy will say you get all your lots back. Yeah. You get the diminution in value of your real estate, you get the cost of altering and demolishing your property. Yeah. You get your consultants, your board planning costs and everything. Yeah. In reality, what happens is the insurer says, well, I could pay you all that, if you get injuncted,
Yep,
what I'm actually going to do is ask you to resubmit your planning application, and I'll pay the additional costs associated with that, because
interesting.
it's going to be much cheaper.
The insurer's controlling.
Yeah.
Yeah, sorry.
And so in delay costs, example, delay costs, you get all your costs back.
Yeah,
And so the insurers often say, well, wait, if there's a delay event, an injunction, I'll get all my costs back. So no, you probably won't, because the insurer might take the view that the injunction is not going to succeed
yes.
and require you to keep working.
Oh, excellent. So just in summary, your 4 points was,
Yeah. So know who you're buying your insurance from, so you're not getting what the insurers are paid on.
Yeah.
You're getting what is in your best interest.
yes,
Ensure that you're not combined with another insured and losing the benefits.
beneficiation point and the endorsement. Yep,
Without knowing.
terms.
Check the terms like limit and excess premium risk, and disclose everything to the insurer, otherwise don't say anything. And agreed conduct can be applied outside rights of light. And it's very useful indeed.
Good framework, thank you. So on to our case study. So I'll just skip through this fairly quickly. So Peckham Boy Holdings, Peckham Boy wish to purchase a 2-acre edge of city centre site, currently available off market for £5 million. Sounds pretty good. Size of 2-acre. However, the vendor is Shark Ventures, an offshore hedge fund, which requires exchange and completion in 5 working days. You're going to have to get your skates on here, Moys. And the local planning authority has granted outline planning permission. So it's not full/detailed. It's not a hybrid. It's purely an outline permission for a development described as demolition of the existing empty and derelict Victorian school buildings. That should be a photograph for our attendees to see, as there was on the previous slide, followed by the erection of a Part 7, Part 8-storey co-living block of up to 250 units, together with a 10-storey residential tower, 20 luxury apartments, incorporating underground car parking, commercial space on the ground floor and associated works. Mr. Rodney Delboy is the moving spirit behind Peckham Boy, has been told by Shark, first, the G.D.V of the scheme is 45 million. The Section 106 planning obligation is not onerous because the local planning authority have accepted the scheme can only provide 2 affordable housing units instead of their policy of 40% affordable due to financial viability. And we touched on financial viability and the developer stacking the expenses column with the insurance premium and the excess, as along with all other costs. The development funding is available, that's the good news, at competitive rates, even more good news, but it's from a subsidiary of Shark, okay? Delboy engages a surveyor who advises him that Slammer and Dunk solicitors' offices opposite the site may suffer an infringement of their right to light if the proposed development is built out. So there's your first red flag, right of light. Solicitors are likely to know very well about this sort of a matter, so they're a high risk potential. We've got an image there, credit GIA. The office copy entries refer to an old restrictive covenant, which appears to preclude the site being used for anything other than primary and or secondary school with an Anglican ethos. 2 red flags, and it gets worse. Delboy engages the surveyor, as we've said, and the surveyor mentions he's been on a recent course and he's heard about the Reverter of Sites Act 1987 and is concerned that the relatives of Lord Snooty, who in 1888 gave the site to trustees to hold for educational purposes, may surface and claim the sale proceeds, Reverter of Site Act legislation from the old School Sales Sites Act in the Victorian times. And finally, for good measure, he notices from the file plan in his preliminary site inspection the possibility of a verge, and it's shown on the plan, a little gap between the public highway and the site, which could present issues of access for vehicles both during the during the construction phase and the operational phase, because that's the only way in across that frontage. Mr. Delboy has had he's got a £500,000 deposit. He was the beneficiary under his late grandfather, Mr. Trotter's will. He's undeterred. He wishes to press on, but the prospective funder says, hang on a minute, and requires Peckham Boy to have adequate legal indemnity insurance, not the word adequate, in place to mitigate the risk that it may never recover its investment, which is going to be significant if the scheme goes south. So it's going to be putting in £4.5 million, and it's concerned about those risks. So over to you, Moys. What if Mr. Rodney Delboy comes to you saying, Moys, what can you do for me here? This is the scenario.
I don't have a lot of time to look at this slide, but
That's not encouraging.
but there are lots of issues there.
Yeah.
And one of them is the purchase price of 5 million seems quite cheap.
Yes.
So that would make me think of transaction undervalue, which you can insure against.
Yes.
The transaction I'm really concerned about here is the one where Shark bought it.
Yeah, right.
And
Interesting.
I'd like to know how much they bought it for and who they bought it from and whether they were related parties.
Ah, yes.
And if they bought it for £1 million, then that transaction could be set aside.
Yes.
Which could mean that our borrower has no entitlement to the property, which could mean that the security just dissolves under the lender.
Oh dear, not happy days.
So I'm making inquiries about a transaction under insurance.
Okay.
I'd be also concerned about the lawyer's KYC, know your client procedures, because an offshore hedge fund, the trail's going to go pretty cold. Slumberg register and all that.
Yes.
And then
Planning permission, does that raise eyebrows as well?
Planning permission makes me think that that somebody's leaned on the authority and the permission might be reviewable because it doesn't satisfy affordable housing criteria.
Interesting.
And so that you'd be potentially applying judicial review cover there if you want to move quickly, which we do.
And with just to make the point with JR in planning, it was speeded up quite a few years back now from the traditional, as soon as, but in any event within 3 months to 6 weeks.
Yeah.
So you've got to get your skates on with the JR challenge, but even so, there's still the risk.
But they did happen. I heard one last week. And the Reverter Act, you can insure against that.
Yes.
But I think you'd need some more information here because you've still got the school building.
Yeah.
And if the use of the school has been transferred to another site,
yes,
then you can probably get away with it.
Yes, but that recent Supreme Court case, the Ritz in Oxford.
Yeah, Ritz.
Yeah. Okay.
But if it hasn't, then
yes.
So I wouldn't be leaping in here.
No. In terms of the covenant and the ransom strip, have you got some thoughts on?
So I think the ransom strip looks eminently insurable. That's the good news.
That's some good news.
So I think it's going to be a ransom strip which you've insured to something you're never going to own.
Yeah.
And slammer and dunk could be dealt with by the Midtown case.
Yes.
Where the judge said, I've been to your offices, you lawyers.
Yes.
So it's right. And you always have the rights anyway.
Yes.
So forget your rights of life.
Yes.
And you need to investigate whether slammer and dunk owned the building or had a lease and how long they had it for. I don't know what sort of stuff.
Yes. Okay. And the missing beneficiaries? Yeah.
So I wonder why Mr. Delboy got the 500K as a deposit.
Yes.
But it suggests it's not necessarily. It may not have been at all financial before then.
Yes.
So again, know your customer, but also what were the circumstances of his inheritance?
Yes.
And are we convinced that the executives did it right? And missing beneficiaries insurance insures the executor.
Okay.
So if it's something
there's some good news, but there's quite a few red flags.
Mostly, I wouldn't be holding my breath.
No. Great. Okay, Moys. Well, I think we've run out of time for questions. I haven't seen any more come in. So I think all that remains is to say thank you very much to our audience. Thank you so much, Moys, for joining. Watch this space. There'll be more Radcliffe Talks real estate in the new year. And I wish everybody a very Merry Christmas and a peaceful and prosperous New Year. Thank you very much.
Thank you, Clive.
Thank you, Moys.
Thanks.